is that I've given a truthful account of what I have seen within the judicial system. And it has taken the loss of the judiciary for Nigeria to, no matter how corrupt a judicial system might be, there are certain precepts and norms. It's like I want to count 1 to 3, and then I'm looking to skip 2. So I just say 1, 3. Where is the 2? So there should be some order, some processes by which you arrive at a particular decision. That is why the court have rules. But when you see the highest judicial body in the country flouting its own rules and acting in a manner that is suggestive of impunity, then you know that something is very abnormal in that situation. When people become so powerful that they don't even care or believe that they are subject to any law.
Thank you so much. I welcome you to Politics Today. I'm your brother, Secret. We, the Nigerian people, have decided to be active citizens. So, we are now involved in every issue affecting our country. We took that decision because we have suffered enough. And freedom is not something anybody will give to you. We have made up our mind to take freedom from our oppressors. We cannot continue like this. In this video, this platform want to present a very strong defense to this world #1 book now, Nigeria and its criminal justice system, written by this human rights defender, Farotimi. We are determined to produce documentary evidence beyond what Farotimi wrote. You see, Farotimi said nothing new. So many legal giants, so many, had in the past said a lot, far more than what Farotimi said. So many Supreme Court justices, in their valedictory session, as they were bowing out, had said so much about the decay in the judiciary. I'm going to present a few of them. But this video is anchored on the last presidential election petition between the Tinubu legal team, that of Atiku Abubakar, and the legal team of P2B. The case which they took to the appeal court, from appeal court to Supreme Court. We're going to look at the performance of the appeal court and that of the Supreme Court. We are doing this platform is doing this in defense of this book, Nigeria and its criminal justice system. We are defending the book because we are presenting the fact that what Farotimi said is even insignificant in relation to what other legal giant has said in the past concerning the judiciary. But we are going to anchor the argument on this video, reviewing the decision of a court in Malawi. A court where you have judges whose loyalty strictly to the law, not compromised in any way. We are talking about a country whose judicial system had not been criminalized and thuggery had not been institutionalized in the already criminalized justice system as we see it in Nigeria. So, we are going to look at the wisdom of the court in Malawi in relation to the blunder that the compromised judicial officers, 5 of them at the appeal court, 7 of them at the Supreme Court. We are looking at the documents presented to the appeal court, 5 justices of the appeal court, by the Labour Party legal team. They went to appeal court and they presented over 8,000 result sheets satisfied by Independent National Electoral Commission. They did not present documents which they picked from the road or which they picked from polling booth agents. They presented documents satisfied in line with court decision, the decision of the appeal court that said, give the petitioners the document you use to conduct the election. In compliance to that directive of the court, INEC satisfied result sheet used in the collation of the result of the 2023 presidential election. And lo and behold, over 8,000 of the satisfied result sheets were blank papers. And Labour Party legal team brought truckload of the said blank paper result sheets before the Court of Appeal panel looking at the petition. Now, this is where the wisdom of the Malawian court comes to bear. The court, both at the appeal court and at the Supreme Court, the justices argued strongly that the petitioners were supposed to go a step further to present weaknesses, to present their own counter result sheet, to contradict the one presented by INEC. That is to say, if you say the document presented by INEC is not authentic, you are supposed to produce evidence, your own result sheet, with the polling booth agents coming to testify so that the validity of the document presented to INEC would then be called to question. Remember the number of result sheets INEC brought to court, INEC satisfied as document used to conduct the election, to collect results, over 8,000 of them. The total number of votes affected by the result sheets, over 4 million. That number of votes, if captured, had altered the outcome of the election. If captured, in line with the provisions of the law, the result of the election will be altered. Because the margin between the first person and the second person is not up to 4 million. The margin between the first person and the third person is not up to 4 million. Assuming the 4 million votes belong to the third person, when you add that vote to the third person, that third person becomes the first person. Now, I have presented to you the decision of the court. Let us now go to the Malawian court. They were faced with the same challenge. As to what do you do when there is a public document before you? Do you need witness for a public document that is before you? If the document contradicts the provisions of the law. The Malawian court said, of what use is inviting, what do you need polling booth agents? What do you need witness for? What do you need another document to counter the one that is before you? If the document that is before you already violates the Constitution, already violates the law, the Malawian court asks a question. When you see TPEX on the result sheet, of what use is witness? Because TPEX on the result sheet makes that result sheet invalid to be accepted and to be used in the collection of results. The Malawian court asks a question, of what use is witness? If you see alteration on the result sheet, somebody wrote 600, later altered it, and then write 800. Do you still need witness to come and testify that the actual figure was supposed to be 600 when you already know that alteration on the result sheet invalidates the document? Do you need witness? The Malawian court asks a question, of what use is witness when you discover that there is conflicting figure moving from one form to the other? The figure that you should transform to another form is different from the one that is on that further form. So you're supposed to know that, look, since this figure was supposed to move from this one to this other one, do you still call witness? What will that witness do? They ask the question, if in tabulating election results, and you discover that Party A scored 30, Party B scored 200, Party C scored 100. Ordinarily, you should know the sum total. But what if you now see 1,000? And that calls to question that the document before you is invalid. They ask a question. If the accredited number of voters in an election, as per the document before you, is maybe 2,000 accredited number of voters, only for you to discover actual vote cast is 7,000. Do you need a witness to tell you that the document before you is invalid? They ask a question. If the document before you is a blank paper and it is certified as document used for collation of results, but then you cannot see the score of the political parties, of what use is witness when you already know that this document before you cannot be used to collect results? Because it's difficult even for the person looking at it to know the score of the different parties. So on what basis was INEC allocating figure to the parties? Of what use is witness? I'm talking about the wisdom of the Malawi court. The court in Malawi. These are the questions they were raising. And they said, when a document already violates the law, there's no need for anybody to call witness. As long as the loyalty of the judicial officers is to the law, the judges, that document is invalid. And whatever it is used for, the outcome arising from this invalid document is also invalid. The wisdom of the court in Malawi. What does that tell you? What we have is a criminalized justice system. The reasoning of the judges also criminalized. That is why a judge will see a document that violates the law and INEC ICT director was before the court, and a copy of the result sheet given to him. Is it the document you used in collating the 2023 presidential election result? He answered yes, because it is satisfied by INEC. In that case, can you let us know from the document before you what is the score of the different parties, APC, PDP, Labour Party, and others? INEC ICT director, the one in charge of the collation, answered the court, I cannot see anything. It's a blank paper. There is nothing written on it. But that's the document used to collect results. The court saw this. Something made them. Something affected their reasoning. That which happened to them, that which affected their reasoning, that is what Dele Farotimi is writing about. In his book, Nigeria and its criminal justice system, justice is to the highest bidder. That is the bone of contention. So, the facts are before us. Day after day, we'll be coming up with relevant documents. You see, I'm making reference to a document, an international conference, lecture delivered this year, 12th of January 2024, by no other than Dr. Livy Uzoukwu, officer, Order of the Niger, Senior Advocate of Nigeria. What was the topic of the lecture? Nigerian judiciary, the lost hope or the last hope of the country. Is Nigerian judiciary the last hope or the lost hope of the country? All the legal giants, all the who is so that gathered in this important occasion were in total agreement that the Nigerian judiciary is the lost hope of the country. It was a sorry tale. People left the conference with pain in their heart.
As chair of NGC, FJSC, NJI, and LPPC, appointments as council, board, and committee members are at his pleasure. He neither confers with fellow justices nor seeks their counsel or input on any matter related to these bodies. He has both the final and the only say. The Chief Justice of Nigeria has power to appoint 80% of members of the council and 60% of members of the Federal Judicial Service Commission. The same applies to NGI and LPPC. Such enormous powers are effortlessly abused. I repeat, such enormous powers are effortlessly abused.
Farotimi said nothing. In the days ahead, you will see what other legal giants have said in the past. You will see what Supreme Court justices, as they were stepping aside during the appellatory session, you see what they said concerning the same decay in the judiciary. And we are making noise. You see a noise here and there. The Farotimi will be thrown into prison, handcuffed, for presenting the truth about a system that is totally rotten, totally institutionalized, everything criminalized. Rather than everybody wake up and say, "Lo, we can't continue like this." somebody is being punished unjustly, using police harassment and all whatnot. AK-47 used to enter into a law chamber to make arrest. A lawyer who wrote a book, handcuffed. The days ahead will present documentary evidence of what others have said in the past. If you believe in the truth and you want to see Nigeria make progress, share this video and subscribe to this channel. We have enough documents. We are coming up with them.
Intriguing that this anomaly, we all know it, and nobody has taken it a duty to do something about it. Valedictory session after valedictory session, lapses and challenges that should be nipped are stated to no avail. Why the silence and seeming contentment?